important at all, huh? Tell me each item there. Don't waste it after. Close this.
I'm sorry we were a little late. Some ceremonial formalities because we have to regretfully say goodbye to our learned brother in 2 days. So, because the Constitution tells us when the time has come. So we were just in a group photograph and other things with the staff and other things. So there are 4 judgments in all in this case. There's a judgment by me. There's a judgment by Justice Kaul. There's a judgment by Justice Narasimha. I'm sorry, by Justice Bhat, and there's a judgment by Justice Narasimha. So, consistent with the importance of the case, I'll begin by reading out some of our portions. There's a degree of agreement and there's a degree of disagreement on how far one has to go. As I see, the degree of disagreement is on how far we have to go. But I'll read out my judgment, then I'll request Justice Kaul to, I shouldn't say I'll read out my judgment, I'll read out parts of the judgment which are relevant. I've dealt with the issue of judicial review and separation of powers. I'll just briefly refer to some of those extracts. The doctrine of separation of powers, as it is traditionally understood, means that each of the 3 organs of the state perform distinct functions in distinct spheres. No branch performs the function of any other branch. Actually, Mr. Sibal, Mr. Solicitor, all of you can take a seat. I mean, you don't have to stand to receive the judgment. It will take a little time, so you can all be seated for a bit.
Obliged.
The traditional understanding of this doctrine, also termed the pure doctrine, does not animate the functioning of most modern democracies. That our constitution does not reflect a rigid understanding of this doctrine has long been acknowledged by the court. In practice, a functional and nuanced version of this doctrine operates, where the essential functions of one arm of the state are not taken over by another arm, and institutional comity guides the actions of each arm. In other words, a functional understanding of the separation of powers demands that no arm of the state reigns supreme over another. The Union of India suggested that this court would be violating the doctrine of separation of powers if it determines the list in this case. The separation of powers undoubtedly forms a part of the basic structure of the Constitution, but equally the power of courts to conduct judicial review is also a basic feature of the Constitution. The doctrine of separation of powers certainly does not operate as a bar against judicial review. In fact, judicial review promotes the separation of powers by seeing to it that no organ acts in excess of its constitutional mandate. It ensures that each organ acts within the bounds of its remit. Further, as discussed in the previous segment of this judgment, the Constitution demands that this court conduct judicial review and enforce the fundamental rights of the people. The framers of our Constitution were no doubt conscious of this doctrine when they provided for the power of judicial review. Being aware of its existence and what it postulates, they chose to adopt Article 32, which vests this court with broad powers. The doctrine of separation of powers cannot therefore stand in the way of this court issuing directions, orders, or writs for the enforcement of fundamental rights. The directions, orders, or writs issued for this purpose cannot encroach upon the domain of the legislature. This court cannot make law. This court cannot make law. It can only interpret it and give effect to it. Page 73 पर एक correction है. Then I'm dealing with now in another segment of the judgment, which is titled "Queerness is not urban or elite." The discussion in this segment has not scratched the surface of the rich history of the lives of LGBTQ persons in India, which continue into the present. Yet even the limited exploration of the literature and reportage on the subject makes it abundantly clear that homosexuality or queerness is not solely an urban concept, nor is it restricted to the upper classes of privileged communities. The discussion in the preceding paragraphs reveals the diversity of the queer population. People may be queer regardless of whether they are from villages, small towns, or semi-urban and urban spaces. Similarly, they may be queer regardless of their caste and economic location. It is not just the English-speaking man with a white-collar job who lives in a metropolitan city and is otherwise affluent who can lay claim to being queer, but also and equally the woman who works in a farm in an agricultural community. Persons may or may not identify with the labels queer, gay, lesbian, trans, etc., either because they speak languages which are not English or for other reasons. But the fact remains that many Indians are gender queer or enter into relationships with others of the same sex. In the words of a person assigned female at birth who worked at a factory in Ajmer, and I've quoted the to imagine queer persons as existing only in urban and affluent spaces is to erase them, even as they exist in other parts of the country. It would also be a mistake to conflate the urban with the elite. This renders invisible large segments of the population who live in urban spaces but are poor or otherwise marginalized. Urban centers are themselves geographically and socially divided along the lines of class, religion, and caste, and not all those who live in cities can be termed elite merely by virtue of their residence in cities. This walk through history is not an attempt by this court to take on the mantle of historians. The discussion demonstrates that the institution of marriage has not remained static or stagnant. To the contrary, it is change which characterizes the institution. All social institutions transmogrify with time, and marriage is no exception. From sati and widow remarriage to child marriage and intercaste or interfaith marriages, marriage has metamorphosed. The institution as we know it today would perhaps be unrecognizable to our ancestors from 200 years ago. Despite vehement opposition to any departure from practice, the institution of marriage has changed. This is an incontrovertible truth. Here it is also important to take note of the fact that these changes were brought about largely by acts of parliament of the legislatures of the states. While the passage of many laws was preceded by significant social activism, it was the legislature which ultimately responded to the call for change. Even as parliament and in some cases the courts expand the liberties of the people to conduct their lives in a manner they see fit in accordance with law, many sections of society remain opposed to these changes. Regardless of such opposition, the institution of marriage has undergone a sea change. It is therefore incorrect to characterize marriage as a static, stagnant, or unchanging institution. Fundamental rights are not merely a restraint on the power of the state, but provisions which promote and safeguard the interests of the citizens. They require the state to restrain its exercise of power and create conducive conditions for the exercise of rights. If such a positive obligation is not read into the state's power, then the rights which are guaranteed by the Constitution would become a dead letter. This is because the question of whether the state is curtailing the rights of citizens would only arise if the citizens have the capacity and capability to exercise such rights in the first place. The withdrawal of the state from the domestic space leaves the disadvantaged party unprotected, since classifying certain actions as being private has different connotations for those with and without power. In the case of personal relationships which are characterized by inequality, the actions of the more powerful person gains immunity from scrutiny and a degree of legitimacy. Thus, all activities in the private space dealing with intimate choices must not readily and blindly be categorized to be beyond the scope of the state's regulation. The state must assess if its interest in democratizing the private space overrides the interests of privacy in a given situation. In pursuance of the power conferred by Articles 245 and 246, read with entry 5 of the concurrent list, Parliament has enacted laws creating and regulating socio-legal institution of marriage. The state legislatures have made amendments to such laws with the assent of the President, since the subject of marriage is in the concurrent list. The petitioners seek that the court recognize the right to marry as a fundamental right. As explained above, this would mean that even if Parliament and the state legislatures have not created an institution of marriage in exercise of their powers in entry 5 of the concurrent list, they would be obligated to create an institution because of the positive postulate encompassed in the right to marry. This argument cannot be accepted. As explained in the previous section, the state through the instrument of law characterizes marriage with two constituent elements, the expressive component and the material component. Marriage may not have attained the social and legal significance it currently has if the state had not regulated through law. Thus, while marriage is not fundamental in itself, it may have attained significance because of the benefits which are realized through regulation. If the court finds that a provision is contrary to Part 3 of the Constitution, it shall declare that it is void, or read it down by deleting phrases, or read words in by adding or substituting phrases to save it from being declared void. If in the present batch of petitions, this court holds that Section 4 of the Special Marriage Act is unconstitutional because it is under-inclusive to the extent that it excludes, by implication, marriage between same-sex couples, the court would either strike down Section 4 of the SMA or follow the workability model submitted by the petitioners. If the court follows the first approach, the purpose of a progressive legislation such as the SMA would be lost. The SMA was enacted to enable persons of different religions and castes to marry. If the SMA is held void for excluding same-sex couples, it would take India back to the pre-independence era, where two persons of different religions and castes were unable to celebrate love in the form of marriage. Such a judicial verdict would not only have the effect of taking the nation back to the era when it was clothed in social inequality and religious intolerance, would also push the courts to choose between eradicating one form of discrimination and prejudice at the cost of permitting another. If this court takes the second approach and reads words into the provisions of the SMA and provisions of other allied laws such as the Indian Succession Act and Hindu Succession Act, it would in effect be entering into the realm of the legislature. The submissions of the petitioners indicate that this court would be required to extensively read words into numerous provisions of the Special Marriage Act and other allied laws. The court is not equipped to undertake an exercise of such wide amplitude because of its institutional limitations. This court would in effect be redrafting the laws in the garb of reading words into the provisions. It is trite law that judicial legislation is impermissible. We are conscious that the courts usually first determine whether if the law is unconstitutional and then proceed to decide on the relief. However, in this case, an exercise to determine whether the SMA is unconstitutional because of under-inclusiveness would be futile because of the limitations of this court's power to grant a remedy. Whether a change should be brought into the legislative regime of the SMA is for Parliament to determine. Parliament has access to varied sources of information and represents in itself a diversity of viewpoints in the polity. The court, in the exercise of the power of judicial review, must be careful not to tread into the legislative domain. It is clarified that this court has not adjudicated upon the validity of any laws other than the SMA, the FMA, the adoption regulations, and the Kara circular. Page 153 पे correction था. The understanding of the Constitution, then I've said the goal of self-development and what it means to be human. This understanding of the Constitution is substantiated on the reading of Part 4 of the Constitution. To illustrate, Article 38 states that the state shall strive to promote the welfare of people. Then I've referred to Article 42 and Article 47. The Constitution, through both positive and negative postulations, inter alia capacitates citizens in their quest to develop themselves. Such capacity building enables them to achieve their full potential in both the private and the public space and to be happy. The Indian Constitution, unlike, say, the South African Constitution, does not expressly provide that the Constitution seeks to improve the quality of life and free the potential of each person. However, such an understanding can be gleaned from the provisions of Part 3 and Part 4. Thus, one of the purposes of the rights framework is to enable the citizenry to attain the goal of self-development. Humans are unique in many respects. We live in complex societies, are able to think, communicate, imagine, strategize, and to do more. However, that which sets us apart from other species does not by itself make us human. These qualities are necessary elements of our humanity, but taken alone, they paint an incomplete picture. In addition to these qualities, our ability to feel love and affection for one another makes us human. We may not be unique in our ability to feel the emotion of love, but it is certainly a fundamental feature of our humanity. We have an innate need to see and to be seen, to have our identity, emotions, and needs fully acknowledged, recognized, and accepted. The ability to feel emotions such as grief, happiness, anger, and affection, and the need to share them with others makes us who we are. As human beings, we seek companionship, and most of us value abiding relationships with other human beings in different forms and capacities. These relationships may take many forms: the natal family, cousins and relatives, friends, romantic partnerships, mentors or students. Of these, the natal family as well as the family created with one's life partner form the fundamental groups of society. The need and ability to be a part of a family forms a core component of our humanity. These relationships, which nourish the emotional and spiritual aspects of our humanity, are important in and of themselves. Further, they are as important to self-development as the intellectual and eventually financial nourishment we receive through education. Self-development cannot be measured solely in terms of educational qualifications and financial capabilities. Such a description is to forget what makes us human. It is insufficient if persons have the ability and freedom to form relationships unregulated by the state. For the full enjoyment of such relationships, it is necessary that the state accord recognition to such relationships. Thus, the right to enter into a union includes the right to associate with a partner of one's choice, according recognition to the association, and ensuring that there is no denial of access to basic goods or services, which is crucial to achieve the goal of self-development. On the other hand, the state could indirectly infringe upon the freedom when it does not create sufficient space to exercise that freedom. A formal associational status or recognition of the association is necessary for the free and unrestricted exercise of the freedom to form intimate associations. Needless to say, there may be reasonable restrictions on this right. However, other than legally valid and binding restrictions, the right to intimate associations must be unrestricted. The state, by not endorsing a form of relationship, encourages certain preferences over others. In a previous segment of this judgment, we have discussed the tangible and intangible benefits of recognizing relationships in the form of marriage. While the tangible benefits of marriage are traceable to the content of law, the intangible benefits are secured merely because the state recognizes the relationship through the instrument of law. Intangible benefits in the form of expressive advantages exist irrespective of the content of the law. Even if the law does not grant any special material benefits to a relationship, the relationship would still be considered to be legitimate in the eyes of society. The freedom to choose a partner and the freedom to enjoy their society, which are essential components of the right to enter into a union and the freedom of intimate association, would be rendered odious if the relationship were to be discriminated against. For the right to have real meaning, the state must recognize a bouquet of entitlements which flow from an abiding relationship of this kind. A failure to recognize such entitlements would result in systemic discrimination against queer couples. Unlike heterosexual couples who may choose to marry, queer couples are not conferred with the right to marry by statute. To remedy this, during the course of the hearing, the Solicitor General of India made a statement that a committee chaired by the Cabinet Secretary will be constituted to set out the rights which will be available to queer couples and unions. The committee shall set out the scope of the benefits which accrue to such couples. I've traced the right to form unions through a variety of provisions of the Constitution, and I'll refer to Article 19(1)(e) among other things. Citizens of India have the right to settle in any part of the territory of India in terms of Article 19(1)(e). They, like all other citizens, may exercise this right in two ways. First, they may build their lives in a place of their choosing in accordance with law, either by themselves or with their partner. They may reside in that place permanently, subject to other reasonable restrictions, including those intended to protect the rights of tribal communities. This right is uniquely significant to persecuted groups, such as queer persons, intercaste couples, or interfaith couples, who migrate from their hometowns to other places in the country, including cities. And second, they may settle down with another person by entering into a lasting relationship with them. In fact, this mode of the exercise of the right under Article 19(1)(e) is encompassed by the first mode, because to many people, building a life includes choosing their life partner. Hence, the right to enter into a union is also grounded in Article 19(1)(e). Article 21 is available to all persons, including queer persons. Article 21 encompasses the rights to dignity, autonomy, and privacy. Each of these facets animates the others. It is not possible to speak of the right to enter into a union without also speaking of the right to intimacy, which emanates from these rights. These rights demand that each individual be free to determine the course of their life as long as their actions are not barred by law. Choosing a life partner is an integral part of determining the course of one's life. Most people consider this decision to be one of the most important decisions of their life, one which defines their very identity. Life partners live together, spend a significant amount of time with one another, merge their respective families, create a family of their own, care for each other in times of sickness, support one another, and much more. Hence, the ability to choose one's partner and to build a life together goes to the root of the right to life and liberty under Article 21. Undoubtedly, many persons choose not to have a life partner, but this is by choice and not by a deprivation of their agency. The law constrains the right to choose a partner in certain situations, such as when they are within prohibited degrees of relationships or are in a consanguineous relationship. All persons, including members of the queer community, have the right to judge the moral quality of the actions in their own lives, and having judged their moral quality, have the right to act on their judgment in the manner they see fit. This attribute is, of course, not absolute and is capable of being regulated by law. In the segment of this judgment on the right to life and liberty, this court noticed that the meaning of liberty is, at its core, the ability to do what one wishes to do and be who one wishes to be in accordance with law. All persons may arrive at a decision regarding what they want to do and who they want to be by exercising their freedom of conscience. They may apply their sense of right and wrong to their lives and live as they desire in accordance with law. Some of the decisions, the moral quality of which they will judge, including the decision on who their life partner will be and the manner in which they will build their life together. Each individual is entitled to decide this for themselves in accordance with their conscience. This court has recognized that equality demands that queer unions, that queer persons are not discriminated against. An abiding cohabitational relationship includes within its fold a union of two individuals, cannot be discriminated against on the basis of sexual orientation. Material and expressive entitlements which flow from a union must be available to couples in queer unions. Any form of discrimination has a disparate impact on queer couples who, unlike heterosexual couples, cannot marry under the current regime. When Article 15 is read in a broader manner indicated above, the word sex in Article 15 takes within its meaning sexual orientation, not only because of the causal relationship between homophobia and sexism, but also because sex is used as a marker of identity. The word sex cannot be read independent of the social and historical context. Thus, sex in Article 15 includes within its fold other markers of identity which are related to sex and gender, such as sexual orientation. Thus, the restriction on the right to enter into a union based on sexual orientation would violate Article 15 of the Constitution. The gender of a person is not the same as their sexuality. A person is a transgender person by virtue of their gender identity. A transgender person may be heterosexual or homosexual, or of any other sexuality. If a transgender person is in a heterosexual relationship and wishes to marry their partner, and if each of them meets the other requirements set out in the applicable law, such a marriage would be recognized by the laws governing marriage. This is because one party would be the bride or the wife in the marriage, and the other party would be the bridegroom or the husband. The laws governing marriage are framed in the context of a heterosexual relationship. Since a transgender person can be in a heterosexual relationship, like a cis male or a cis female, a union between a trans woman and a trans man, or a trans woman and a man, or a trans man and a woman can be registered under the marriage laws. The transgender community consists of inter alia transgender men and transgender women. A transgender man has the right to marry a woman under the laws governing marriage in the country, including personal laws. Similarly, a transgender woman has the right to marry a man. A transgender man and a transgender woman can also marry. Intersex persons who identify as a man or a woman and seek to enter into a heterosexual marriage would also have a right to marry. Any other interpretation of the laws governing marriage would be contrary to Section 3 of the Transgender Persons Act and Article 15 of the Constitution. Now I've gone to the CARA regulations, Regulation 5.3 of the adoption regulations, and I've said that Regulation 5.3 of the adoption regulations exceeds the scope of the JJI. However, Regulation 5.3 of the adoption regulations bars unmarried partners from being prospective adoptive parents. These regulations only permit persons to adopt in an individual capacity and not jointly as an unmarried couple. Regulation 5.2 states that every person, irrespective of whether they are married or unmarried, will be able to be prospective adoptive parents. The subsequent criteria in Clause A, that is the requirement for the consent of both spouses if they are married, does not exclude an unmarried couple from adopting. It only states that if a couple is married, then the consent of both the parties shall be secured. However, Regulation 5.3 in express terms excludes unmarried couples from adopting by prescribing the condition that the couple must have been in 2 years of a stable marital relationship. Page 210. As observed in the previous paragraph, the the Juvenile Justice Act does not preclude unmarried couples from adopting. Though Section 57 of the Act grants CARA the power to prescribe additional criteria, the criteria must not exceed the scope of the legislative policy. Neither the general principles guiding the JJ Act nor Section 57 in particular preclude unmarried couples from adopting a child. In fact, all the other criteria ensure the child's best interest. The Union of India has not proved that precluding unmarried couples from adopting a child, even though the same people are eligible to adopt in their individual capacity, is in the child's best interest. Thus, CARA has exceeded its authority by prescribing an additional condition by way of Regulation 5(3), which is contrary to the tenor of the Juvenile Justice Act and Section 57 in particular. The adoption regulations use marriage as a yardstick to classify couples. There is an intelligible differentia in using marriage as an indicator to classify couples in the sense that married couples can easily be distinguished from unmarried couples. However, the differentia does not have a rational nexus with the object sought to be achieved by the CARA regulations, which is to ensure that the best interest of the child is protected. Placing a child in a stable family is undoubtedly in pursuance of a child's interest. However, the respondents have not placed any data on the record to support their claim that only married relationships can provide stability. It is true that separating from a married partner is a cumbersome process when compared to separating from a partner with whom a person is in a live-in relationship. This is because separation from a married partner is regulated by the law, while live-in relationships are unregulated by law, other than for the limited purposes of domestic violence. For instance, the law deters a person from securing a divorce immediately by prescribing conditions such as a 6-month waiting period after a petition for divorce by mutual consent is filed. Merely because a marriage is regulated by the law, it cannot be assumed that marriage alone or that every marriage accords stability to a relationship. Similarly, it cannot also be inferred that the couples who are not in a married relationships are not serious about the relationship. The stability of the household depends on various factors, such as the effort and involvement of the partners in establishing and running a household, creating a safe space at home, creating a healthy work-life balance, and a household where mental, physical, and emotional violence is not inflicted on one another. There is no single form of a stable household. There is no material on the record to prove the claim that only a married heterosexual couple would be able to provide stability to the child. In fact, this court has already recognized the pluralistic values of our Constitution, which guarantee a right to different forms of association. Regulation 5(3), though facially neutral, indirectly discriminates against atypical unions, such as the relationship between non-heterosexual partners, which have not been recognized by the state. Queer marriages have not been recognized by the state, and queer persons in atypical unions cannot yet enter into a marriage which is recognized by the state. Though the additional criteria prescribed by the adoption regulations would also affect a heterosexual person's eligibility to adopt a child, it would disproportionately affect non-heterosexual couples. This is because the state has not conferred legal recognition to unions between queer persons in the form of marriage. Consequently, an unmarried heterosexual couple who wishes to adopt a child has the option of marrying to meet the eligibility criteria for adoption. However, this option is not available to queer couples. When Regulation 5(3) is understood in the light of this position, a queer person who is in a relationship can only adopt in an individual capacity. This exclusion has the effect of reinforcing the disadvantage already faced by the queer community. The law cannot make an assumption about good and bad parenting based on the sexuality of individuals. Such an assumption perpetuates a stereotype based on sexuality that only heterosexuals are good parents and all other parents are bad parents, which is prohibited by Article 15. This assumption is not different from the assumption that individuals of a certain class or caste or religion are better parents. In view of the above observations, the adoption regulation is violative of Article 15 for discriminating against the queer community. According to the adoption regulations, unmarried couples cannot jointly adopt a child. Though the additional criteria prescribed by the CARA circular would also affect a heterosexual person's eligibility to adopt a child, it would disproportionately affect non-heterosexual couples. This is because the state has not conferred legal recognition to the unions between queer persons in the form of marriage. Consequently, an unmarried heterosexual couple who wishes to adopt a child has the option of marrying to meet the eligibility criteria for adoption. However, this is not an option for queer couples. When the CARA circular is read in the light of this legal position, a person of the queer community would be forced to choose between their wish to be an adoptive parent and their desire to enter into a partnership with a person they feel love and affinity with. This exclusion has the effect of reinforcing the disadvantage already faced by the queer community. For these reasons and the reasons recorded in Section D so and so, the Kara Circular is violative of Article 15 of the Constitution. I've addressed myself to my disagreement with the scholarly judgment of my learned brother, Justice Bhatt. My learned brother relies on the example of Article 19(1)(d) to buttress this point. He states that in the absence of a law which casts a duty on the state to provide transportation through roads, a citizen cannot approach the court and seek the construction of a road to enforce the right to move freely. The opinion of my learned brother fails to have noted the judgment of a three-judge bench of this court in state of Himachal Pradesh versus Umed Ram Sharma. I'll not read the rest of that. Contrary to what is stated in the judgment of Bhatt, the directions in my judgment do not require the state to create a social or legal status or a social institution. The directions are with a view to recognizing the choice that a person makes for themselves when they choose another to be their partner for life. The directions seek to make that choice a meaningful one. Nowhere do they create an institution of any kind. Rather, they give effect to the fundamental rights in Part 3 of the Constitution. This is the mandate of this court under Article 32, which says that the Supreme Court shall have the power to issue directions or orders or writs for the enforcement of any of the rights conferred by this part. No response is forthcoming to my detailed exposition of the scope of the powers of this court under Article 32. In section D1 of my judgment, in fact, Justice Bhatt himself recognized that courts often enable and oblige the state to take measures. My learned brother also arrives at the conclusion that the state is indirectly discriminating against the queer community, but fails to exercise the power vested in this court by Article 32 to alleviate this discrimination in any way. This court is not through judicial diktat creating a legal regime exclusively for persons of the queer community, but merely recognizing the duty of the state to recognize the entitlements flowing from exercising the right to choose a life partner. Page 234. The judgment of my learned brother contradicts itself when he holds that the SMA is not discriminatory by relying on its object on the one hand, and that the state has indirectly discriminated against the queer community because it is the effect and not the object which is relevant on the other. My learned brother discusses in detail the deprivation, exclusion, and discrimination faced by the queer community. In effect, he firstly recognizes that they have a right not to be discriminated against, and secondly holds that the actions of the state have the effect of discriminating against them. However, he does not take the step which logically flows from such a ruling, which is to pass directions to obviate such discrimination and ensure the realization of the rights of the queer community. I cannot bring myself to agree with this approach. The realization of a right is effectuated when there is a remedy available to enforce it. The principle of ubi jus, ibi remedium, that is, an infringement of a right as a remedy, which has been applied in the context of civil law for centuries, cannot be ignored in the constitutional context. Absent the grant of remedies, the formulation of doctrines is no more than judicial platitudes. In view of the deeming fiction created by Section 12 of the Hindu Adoptions and Maintenance Act 1956 and Section 63 of the JJ Act, an adopted child is a legitimate child of the adopting couple. The manner of determination of legitimacy prescribed by Section 112 of the Indian Evidence Act shall not apply in view of the deeming fiction created by Section 12 of the Hindu Adoptions and Maintenance Act and Section 63 of the JJ Act. Thus, all the benefits which are available under the law to a legitimate child who has been validly adopted of a married couple will equally be available to the legitimate child of an unmarried couple. For example, Section 20 of the Hindu Adoptions Act, which provides that a Hindu is to maintain their children, does not make any distinction between a legitimate child of a married and unmarried couple. Similarly, succession law in India does not differentiate between the child of a married and unmarried couple if the child has been adopted by following the due process of law. Further, the breakdown of the relationship of an unmarried couple will not lead to a change in applicable law, because the child will continue to be a legitimate child even after the breakdown of the relationship. It is therefore unclear what the disastrous consequences referred to are. My learned brother has also failed to address whether Regulation 5.3 is discriminatory for distinguishing between married and unmarried couples for the purpose of adoption and for the disproportionate impact that it has on the members of the queer community, while simultaneously holding that the state cannot on any account make regulations that are facially or indirectly discriminatory on the ground of sexual orientation. Now I'll pronounce my directions. The first part of my directions are directions to obviate discrimination. Counsel for the petitioners and some counsel for the respondents advanced extensive submissions on the various forms of violence and discrimination that society and the state machinery inflict upon the queer community, and especially queer couples. This has been discussed in detail in the prefatory part of the judgment. Counsel sought directions to obviate such violence and discrimination. Now my directions. A. The union government, state governments, and governments of union territories are directed to 1. Ensure that the queer community is not discriminated against because of their gender identity or sexual orientation. 2. Ensure that there is no discrimination in access to goods and services to the queer community which are available to the public. 3. Take steps to sensitize the public about queer identity, including that it is natural and not a mental disorder. 4. Establish hotline numbers that the queer community can contact when they face harassment and violence in any form. 5. Establish and publicize the availability of safe houses or garima grahs in all districts to provide shelter to members of the queer community who are facing violence or discrimination. 6. Ensure that treatments offered by doctors or other persons which aim to change gender identity or sexual orientation are seized with immediate effect. 7. Ensure that intersex children are not forced to undergo operations with regard only to their sex, especially at an age when they are unable to fully comprehend and consent to such operations. 8. Recognize the self-identified gender of all persons, including transgender persons, hijras, and others, with socio-cultural identities in India as male, female, or third gender. No person shall be forced to undergo hormonal therapy or sterilization or any other medical procedure either as a condition or prerequisite to grant legal recognition to their gender identity or otherwise. B. The appropriate government and the Mental Health Care Act must formulate modules covering the mental health of queer persons in their programs under Section 29(1). Programs to reduce suicides and attempted suicides envisaged by Section 29(2) must include provisions which tackle queer identity. C. The following directions are issued to the police machinery. 1. There shall be no harassment of queer couples by summoning them to the police station or visiting their places of residence solely to interrogate them about their gender identity or sexual orientation. 2. They shall not force queer persons to return to their natal families if they do not wish to return to them. 3. When a police complaint is filed by queer persons alleging that their family is restraining their freedom of movement, they shall, on verifying the genuineness of the complaint, ensure that their freedom is not curtailed. 4. When a police complaint is filed apprehending violence from the family for the reason that the complainant is queer or is in a queer relationship, they shall, on verifying the genuineness of the complaint, ensure due protection. And 5. Before registering an FIR against a queer couple or one of the parties in a queer relationship, where the FIR is sought to be registered in relation to their relationship, they shall conduct a preliminary inquiry in terms of Lalita Kumari versus Government of UP to ensure that the complaint discloses a cognizable offense. The police must first determine if the person is an adult. If the person is an adult and is in a consensual relationship with another person of the same or different gender, or has left their natal home of their own volition, the police shall close the complaint after recording a statement to this effect. Conclusions and orders of enforcement. In view of the discussion above, the following are the conclusions. This court is vested with the authority to hear this case. Under Article 32, this court has the power to issue directions, orders, or writs for the enforcement of the rights in Part 3. B. Queerness is a natural phenomenon known to India since ancient times. It is not urban or elite. C. There is no universal conception of the institution of marriage, nor is it static. Under Articles 245 and 246 of the Constitution, read with entry 5 of List 3 to the 7th Schedule, it lies within the domain of Parliament and the state legislatures to enact laws recognizing and regulating queer marriage. D. Marriage has attained significance as a legal institution largely because of regulation by the state. By recognizing a relationship in the form of marriage, the state grants material benefits exclusive to marriage. E. The state has an interest in regulating the intimate zone to democratize personal relationships. F. The issue of whether the Constitution recognized the right to marry did not arise before this court in Justice K.S. Puttaswamy, 9 judges, Shafin Jahan, and Shakti Vahini. G. The Constitution does not expressly recognize a fundamental right to marry. An institution cannot be elevated to the realm of a fundamental right based on the content accorded to it by law. However, several facets of the marital relationship are reflections of constitutional values including the right to human dignity and the right to life and personal liberty. H. This court cannot either strike down the constitutional validity of the Special Marriage Act or read words into the Special Marriage Act because of its institutional limitations. This court cannot read words into the provisions of the SMA and provisions of other laws, allied laws, such as the Indian Succession Act and the Hindu Succession Act, because that would amount to judicial legislation. The court, in the exercise of the power of judicial review, must steer clear of matters, particularly those impinging on policy, which fall within the legislative domain. I. The freedom of all persons, including queer couples, to enter into a union is protected by Part 3 of the Constitution. The failure of the state to recognize the bouquet of entitlements which flow from a union would result in a disparate impact on queer couples who cannot marry under the current legal regime. J. In Article 15.1, the word sex must be read to include sexual orientation, not only because of the causal relationship between homophobia and sexism, but also because the word sex is used as a marker of identity, which cannot be read independent of the social and historical context. K. The right to enter into a union cannot be restricted based on sexual orientation. Such a restriction will be violative of Article 15. Thus, this freedom is available to all persons, regardless of gender identity or sexual orientation. L. The decisions in Navtej and Justice K.S. Puttaswamy, 9 judges, recognize the right of queer couples to exercise the choice to enter into a union. This relationship is protected from external threat. Discrimination on the basis of sexual orientation will violate Article 15. M. Transgender persons in heterosexual relationships have the right to marry under existing law, including personal laws which regulate marriage. N. Intersex persons who identify as either male or female have the right to marry under existing law, including personal laws which regulate marriage. O. The state must enable the LGBTQ community to exercise its rights under the Constitution. Queer persons have the right to freedom from coercion from their natal families, agencies of the states, including the police and other persons. P. Unmarried couples, including queer couples, can jointly adopt a child. Regulation 5.3 of the Adoption Regulations is ultra vires the Juvenile Justice Act, Articles 14 and 15. Regulation 5.3 is read down to exclude the word marital. The reference to a couple in Regulation 5 includes both married and unmarried couples as well as queer couples. The principle in Regulation 5.2a that the consent of spouses in a marriage must be obtained if they wish to adopt a child together is equally applicable to unmarried couples who seek to jointly adopt a child. However, while framing regulations, the state may impose conditions which will subserve the best interest and welfare of the child in terms of the exposition in this judgment. Q. In view of the interpretation of Regulation 5.3 of the adoption regulations, the issue of whether the CARA circular disproportionately impacts the queer community no longer arises. R. The union government, state governments, and governments of union territories shall not discriminate against the freedom of queer persons to enter into union with benefits under law. And S. We record the assurance of the Solicitor General that the union government will constitute a committee chaired by the Cabinet Secretary for the purpose of defining and elucidating the scope of the entitlements of queer couples who are in unions. The committee shall include experts with domain knowledge and experience in dealing with the social, psychological, and emotional needs of persons belonging to the queer community, as well as members of the queer community. The committee shall, before finalizing its decisions, conduct wide stakeholder consultation amongst persons belonging to the queer community, including persons belonging to marginalized groups, and with the governments of the states and union territories. The committee shall, in terms of the exposition in this judgment, consider the following. 1. Enabling partners in a queer relationship, A, to be treated as a part of the same family for the purposes of a ration card, and B, to have the facility of a joint bank account with the option to name the partner as a nominee in case of death. 2. In terms of the decision in Common Cause versus Union of India, as modified by Common Cause versus Union of India 2, medical practitioners have a duty to consult family or next of kin or next friend in the event of patients who are terminally ill and have not executed an advance directive. Parties in a union may be considered family for this purpose. 3. Jail visitation rights and the right to access the body of the deceased partner and arrange the last rites. And 4. Legal consequences such as succession rights, maintenance, financial benefits such as under the Income Tax Act 1961, rights flowing from employment such as gratuity and family pension and insurance. The report of the committee chaired by the Cabinet Secretary shall be implemented at the administrative level by the Union government and the governments of the states and the union territories. This is what.
I've had the benefit of the exhaustive and erudite judgment of Chief Justice Chandrachud, which enumerates the prevalence of these relationships in history, the constitutional recognition of the rights to form union, in other words, what I categorize as civil unions, and the necessity of laying down guidelines to protect the non-heterosexual unions. In a way, this is a step forward from the decriminalization of private consensual sexual activities. However, the subject matter itself persuades me to pen down a few words while broadly agreeing with my brother's judgment. I've dealt with the historical prevalence of non-heterosexual unions. I've said that it is no longer res integra, that the duty of a constitutional court is to uphold the rights enshrined in the Constitution and not to be swayed by a majoritarian tendency or popular perceptions. This court has always been guided by constitutional morality and not by social morality. Pluralistic social fabrics has been an integral part of the Indian culture. I have referred to some observations from the Rig Veda and the Somdas Satya Sargra. And then I've said the significant aspect is that the same-sex union were recognized in antiquity not simply as unions that facilitate sexual activity, but as relationships that foster love, emotional support, and mutual care. I've referred to some traditions in the Sufi traditions. Then I've said the marriage as an institution developed historically and served various social functions. It was only later in its long history that it came to be legally recognized and codified. However, these laws regulated only one type of social historical union, that is the heterosexual union. It would thus be misconceived to claim that non-heterosexual unions are only a facet of modern social milieu. The objective of penning down this section is to provide perspective on the existence of non-heterosexual unions, despite continued effort towards their erasure by heteronormity of majority. The non-heterosexual unions are entitled to protection under a constitutional scheme. I have referred to the necessity of recognizing what I have categorized as civil unions. The judgment of the Chief Justice notes the right to form union is a feature of Article 19 and 21. Therefore, the principle of equality enumerated under Article 14 and 50 demand this right to be available to all regardless of sexual orientation and gender. Having recognized this right, this court has taken on board the statement of the learned Solicitor General to constitute a committee to set out the scope of the benefits available to such union. I agree with the Honorable Chief Justice. I have referred to the Special Marriage Act and discussed the statement, object, and reason therefore. From the above, the SMA postulates a special form of marriage available to any person in India, irrespective of faith. Therefore, SMA provides a secular framework for solemnization and registration of marriage. It is here that I respectfully disagree with my brother Justice Bhat that the sole intention of SMA was to enable marriage of heterosexual couples exclusively. To my mind, the stated objective of SMA was not to regulate marriages on the basis of sexual orientation. This cannot be so, as it would amount to conflating the differentia with the objective of the statutes. Although substantive provisions of SMA confer benefits only on heterosexual relationships, this does not automatically reflect the objective of the statutes. I've said if the intent of the SMA was to facilitate interfaith marriages, then there would be no rational nexus with the classification it makes of excluding not heterosexual relationships. Then I've referred to the regulation of only heterosexual marriages would not be legitimate state objective, more so in cases where ex officio protected categories under Article 15(1) of the Constitution. However, I recognize, therefore, I have said that if this was so, the SMA would be violative of Article 14. However, I recognize that there are multifarious interpretative difficulties in reading the SMA to include marriage between non-heterosexual relationships. These have been enumerated in a significant detail in the opinions of both the Honorable Chief Justice and Justice Bhat. I also agree that the entitlements evolving from marriage are spread across the proverbial spider web of legislations and regulations. As rightly pointed out by the learned Solicitor General, tinkering with the scope of marriage under SMA Act can have a cascading effect across these disparate laws. Um, In fact, the presence of this web of statutes show that discrimination under SMA is but one example of a larger, more deeper form of social discrimination against non-heterosexual people that is pervasive and structural in nature. Ordinarily, such an intensive form of discrimination should require keener and more intensive judicial scrutiny, but then that's the statute. Then I say non-heterosexual unions and heterosexual unions marriages ought to be considered as two sides of the same coin, both in terms of recognition and consequential benefits. The only deficiency at present is the absence of a suitable regulatory framework for such unions. I refer to Navtej's view. I believe this movement presents an opportunity of reckoning with this historical injustice and casts a collective duty upon all constitutional institutions to take affirmative steps to remedy the discrimination. The next step in due course would be to create an edifice of governance that would give meaningful realization to the rights to enter into the union, whether termed as marriage or as unions. Then I've referred to the interpreting statutes using constitutional principles. As noted above, the benefits pertaining to marriage are spread across several incidental legislation and regulations. These statutes presently do not explicitly extend to civil unions. However, now that we have recognized the right to enter into civil union, such statutes must be read in a manner to give effect to this right, together with the principles of equality and non-discrimination under Article 14 and 15. In other words, statutory interpretations must be in consonance with constitutional principles that are enumerated by this court. Needless to say, this should not detract from the committee's task of ironing out the nitty-gritties of the entitlement of civil union. This exercise is necessary to foster a greater coherence within the legal system as a whole, both intercede the statutes and between statutes and the Constitution. I refer to some views from how the German courts and the South African courts have dealt with these issues. Then I've referred to the interpretation on issue of public policy. I've said this technique of reading constitutional values should be used harmoniously with other canons of statutory interpretation. I've gone on to the need for anti-discrimination law. I wholeheartedly in agreement with the opinion of Honorable Chief Justice that there is need for separate anti-discrimination law, which inter alia prohibits discrimination on the basis of sexual presentation. Presently, there are several laws that have anti-discrimination aspects. However, they are fragmented and may fail to capture the multitudinous forms of discrimination. Another compelling reason for a law that places a horizontal duty of anti-discrimination is provided by the spirit of Article 15, which prohibits discrimination both by the state and private actors. My suggestions for anti-discrimination law are as follows. First, such law should recognize discrimination in an intersectional manner. This is to say, in assessing any instance of discrimination, the court cannot confine itself to a singular form of discrimination. Instead, discrimination must be looked at as a confluence of factors, as identities and individual instances of oppression that intersect and create a distinct form of disadvantage. Discrimination laws can only be effective if they address the types of inequalities that have developed in a given society. Refer to the equal rights to equal love. The principle of equality mandates the non-heterosexual union are not excluded from the mainstream of socio-political framework. However, the next step would be to examine the framework itself. I believe the recognition of non-heterosexual union can challenge culturally ordained gender roles, even in heterosexual relationships. I've given some examples of it. Did not read it here. You can see it. In a non-heterosexual union, duties, obligations are primarily dictated by cultural ordained gender norms. Legal recognition aids social acceptance, which in turn increases the queer participation in public space. Through the medium of legal recognition, queer persons will have a greater opportunity to be seen and heard in ways not previously possible. Queer expression will help facilitate an expansive social dialogue cutting across communities and generations. This dialogue will help us reimagine our relationships in a manner that emphasizes the values such as mutual respect, companionship, and empathy. Conclusion. Is this end where we have arrived? The answer must be an emphatic no. Legal recognition of non-heterosexual unions represents a step towards the marriage equality. At the same time, marriage is not an end itself. Our Constitution contemplates a holistic understanding of equality which applies to all spheres of life. The practice of equality necessitates acceptance and protection of individual choices. The capacity of non-heterosexual couples for love, commitment, and responsibility is no less worthy of regard than the heterosexual couples. Let us preserve this autonomy so long as it does not infringe on the rights of the others. After all, it is my life in the song by Bon Jovi.
Having had the benefit of reading the draft and the revised opinions circulated by the learned Chief Justice, we find it necessary to pen our reasoning and conclusions in this separate judgment. The learned Chief Justice has recorded in detail the submissions by counsel and claims made. They therefore do not require iteration. Similarly, the sections addressing the Union government's preliminary objections, that is the discussion on the court's authority to hear the case and that queerness is a natural phenomenon that is neither urban nor elite, are parts we have no hesitation in agreeing with. However, we do not agree with the conclusions arrived by the learned Chief Justice and the directions issued. We do not agree with certain premises and conclusions that he has recorded. They are: one, that there exists no fundamental. We do agree with the premises and conclusions that he has recorded. They are that there exists no fundamental right to marry under the Constitution, that the Special Marriage Act is neither unconstitutional nor can it be interpreted in such a manner as to enable marriage between queer persons, and that transgender persons in heterosexual relationships have the right to solemnize marriage under the existing legal frameworks. We have briefly highlighted our main points of agreement and reasoned in more detail those aspects with which respectfully we cannot persuade ourselves to concur. We had the benefit of perusing the concurring opinion of Justice Narasimha. We endorse those observations and conclusions fully. The reasoning and conclusions shall be read as supplementing that of the present judgment. For long periods in societies, many societies, the choice of a matrimonial was not free. It was bound by social constraints. Much of the time, marriage was seen as an institution meant for procreation and sexual union of spouses. In most societies, marriage had cast roles for the spouse. They were fairly inflexible, with men controlling most decisions and women placed in a subordinate position with little or no voice, and for the longest time, no legal authority, autonomy, or agency. For millennia, custom, tradition, and law subordinated wives to husbands. Notions of equality of partners or their roles were uncommon, if not totally unheard of. All these underwent radical change. Legislative activities aimed at bringing about gender parity through prohibiting prevailing practices that further inequality and sometimes even criminalize certain customs, resulting in legislations such as Equal Remuneration Act, the Dowry Prohibition Act, introduction of provisions in the criminal law which gave teeth to such provisions, such as Section 498, Section 113A and B of the Evidence Act, etc. Other practices aimed at realization of social goals and furthering the mandate of Article 15(3) in respect of children, such as the right to free universal education under Article 21A, the Right to Free Education under Act 2009, the Child Labor Prohibition and Regulation Act 1986, the POCSO, what we call as POCSO, the Juvenile Justice Act, etc. In all these, the Parliament or concerned legislatures donned the role of reformers and furthered the express provisions of the Constitution, enjoining state action in furtherance of Articles 15(2), 15(3), 17, 23, and 24. Marriage has historically been a union solemnized as per customs, a personal law tracing its origin to religious texts. legislative activity in the personal law field so far has been largely, though not wholly, to codify prevailing customs and traditions and regulating them only where needed. The instances that stand out are the enactment of the Succession Act, the Hindu Women's Right to Property Act, 1937, the Hindu Marriage Act, the Adoptions and Maintenance Act, the Hindu Succession Act, the Hindu Minority and Guardianship Act, and the Indian Divorce Act. As amended, the Muslim Personal Law Sharia Application Act and the Anand Marriage Act, 1909. These laws mostly codified traditions and customs which existed and also, to an extent, regulated marriages and succession laws. They also sought to introduce reforms. For the first time, monogamy was enacted as a norm applicable to all Hindus. Likewise, the option of divorce was enacted together with grounds on which other remedies such as judicial separation and maintenance could be sought. Further, the minimum age of marriage was also enacted through provisions in various personal laws and enforced through the Prohibition of Child Marriage Act. Thus seen that two kinds of legislations have regulated marriage. The first, like SMA, HMA, the Hindu Disabilities Removal Act and the Hindu Widows Remarriage Act removed barriers and enabled exercise of meaningful choice, especially to women. The second kind of laws are those which enacted restrictive guidelines, essentially to further an orderly society or to protect women, define minimum age for marriage, child marriage restraint, marriage of individuals within prohibited degrees of relationships, etc. Whereas some restrictions, in a sense, codified and recognized existing customs, such as being enacted by enacting prohibited degrees of relationships, the rule against insanity, rules enabling declaration of nullity or divorce on ground others were meant to further interests of women and children. Such reforming and codification, however, did not cover the entire field. For instance, in the field of succession and inheritance, the Hindu Succession Act enacts only certain broad features, leaving untouched the rights of various communities and sections of Hindus to work out their rights in succession to joint family and co-parcenary property. And this unwritten codified law is enforced not only in regard to inheritance, but also in the field of taxation. Likewise, the law accommodates and accords primacy to customs. Similarly, also recognizes customary divorce amongst Hindus. Neither the Hindu Marriage Act nor the Hindu Succession Act apply to members of tribal communities. In fact, in the latest 3-judge bench decision in Revana Siddhappa versus Mallikarjuna, this court clarified that with the enactment of Section 16 of HMA, the legitimacy conferred upon children born of void or voidable marriages would be that they are entitled only to a share in their parents' property, but cannot claim it of their own right, as a consequence of which they cannot seek partition during the lifetime of their parents. The court also held that they cannot claim any rights other than what was expressly provided for. Thus, uncodified law and custom was upheld. The role of the legislature has been to act as a codifier and in many instances not enact or codify existing customs or practices, and wherever necessary intervene in furtherance of Articles 14 and 15(3) to enact laws. Parliament has intervened and facilitated creation of social status, this is marriage through SMA, and enabled the creation of the institution of adoption, which was available amongst only certain communities. These and other legislative interventions are the result of the state interest in reforms or furthering the interests of given communities or persons. For these reasons, we do not particularly subscribe to the characterization of democratizing intimate zones as discussed in the learned Chief Justice's opinion. These outcomes were driven by enacted law. Furthermore, there was state interest which impelled regulation of such relationships, as for instance, ensuring that minimum marriage age for girls. Likewise, there is state interest in regulating what kind of relationships, that is, prohibited degrees of relationship, should be enacted as disqualifications to marriage. Then there is a discussion or summation of the jurisprudence on Article 21 and the various facets which this court has recognized, such as privacy, choice, autonomy, and dignity. Then we move on. The court's intervention in oft-cited decisions on behalf of the petitioners has been to protect citizens or those approaching them against threats of violence. The instances are Shakti Vahini, Lata Singh, Shafin Jahan, Lakshmi Bai Chandrachud, etc. These decisions were based on the state's duty to protect citizens and enable the exercise of their individual choice in the face of threats. Other decisions, that is Joseph Shine, Navtej, and Independent Thought, were instances where specific provisions that criminalized or made exceptions to criminal behavior were struck down or read down in the enforcement of fundamental rights. That is Articles 14, 15, and 21. Along the way, Puttaswamy articulated the broadest right to privacy, which embraces within its fold the right to exercise one's choice of a life partner and to lead the life free from external barriers. This court has recognized that marriage is a social institution. As elaborated in Part 1, marriage existed and exists historically and chronologically in all of the senses because people married before the rise of the state as a concept. Therefore, marriage as an institution is prior to the state, it precedes it. The status is still not one that is conferred by the state, unlike the license regime in the US. This implies that the marriage structure exists regardless of the state, which can later utilize or accommodate but cannot abolish it. Under this view, terms of a marriage are set to a large extent independently of the state. Its source is external. That source defines the boundaries of marriage. This implies that state power to regulate marriage does not sit easy with the idea of marriage as a fundamental right. In attempting to analyze the claim to fundamental right, there are two primarily competing claims about the nature of marriage. One being that the state should exercise more control over marriage to support traditional purposes and perceptions. This is the quotation. And the other, that each individual should have the right to define marriage for themselves. If indeed there is a right to marry, unless it is elevated to a right akin to Articles 17, 23, and 24, which apply to both state and non-state agencies, and are cast in positive, in fact, emphatic terms, it cannot be operationalized. These provisions most emphatically create positive obligations. Likewise, Articles 15.3, 15.4, 15.6, as well as 16.4, 16.6 highlight state interest in creating conditions to further the goal of non-discrimination. Yet the previous decisions of this court have carefully held such provisions to enable the state and in the sense oblige it to take measures, but ruled out court-mandated policies and laws. In our considered opinion, this is not, however, one such case where the court can make a departure from such a rule and require the state to create social or legal status. What is being asked for by the petitioners is state intervention in enabling marriage between queer or non-heterosexual couples. Civil marriage or recognition of any such relationship with such status cannot exist in the absence of a statute. The demand hence is that of a right of access to a publicly created and administered institution. There is a paradox here or a contradiction which runs to the root of the issue and weighs on this court's mind heavily, in that the creation of the institution here depends on state action, which is sought to be compelled through the agency of this court. All decisions relied upon Puttaswamy, Navtej, Shakti Vahini, and Deepika contain broad observations with respect to individuals' choice of their partners and also a reference to non-conventional relationships. Some observations are undoubtedly to be found in these judgments that cannot be referenced to hold that a right to marry automatically flows from the manner of the provisions of Part 3 which the petitioners assert. There cannot, for the above reasons, be a per se assertion that there exists an unqualified right to marry, which requires treatment as a fundamental freedom, We agree on this conclusion arrived at by the learned Chief Justice and his analysis of all these cases, that the Constitution does not expressly recognize a right to marry. While we agree that there is a right, which we characterize as a right to a relationship, which is recognized in Navtej, that the queer couples and other relationships of that kind can have a union. We characterize it as a right to relationship to avoid confusion. We squarely recognize that it falls within Article 21, as already recognized in these cases. The right to relationship here includes the right to choose a partner, to cohabit and enjoy physical intimacy with them, to live the way they wish to, and the other rights that flow from the right to privacy, autonomy, and dignity. They are, like all citizens, entitled to live freely and express this choice undisturbed in society. Whenever the right to enjoyment of such relationship is under threat of violence or coercion, the state is bound to extend necessary protection. That is the natural consequence of this court's judgments in Navtej, Puttaswamy, etc. If it is agreed that marriage is a social institution with which the state is unconcerned, except to the limited state interest in regulating some aspects of it, does it follow that any section of the society, leaving aside the issue of rights of non-heterosexual couples, which wishes for the creation of a like social institution, or even an entry into a zone which is not popular or otherwise does not fall within the institution of marriage, can seek relief of its creation by court intervention? In the draft circulated by the learned Chief Justice, the reasoning that there is no fundamental right to marry, and thereafter, nevertheless, to proceed to delineate the facets of features which unions other than marriage are deprived of, where it's a closer look. The summation of various rights which such couple is said to be deprived of is used to delineate the contours of the right to enter into a union and justify a positive obligation. There cannot be any doubt that individuals have have the choice of their life partners and the right to live the lives they wish to undisturbed. This is the essence of what this jurisprudence of this court has been. That is explanation of the right to life and other rights enumerated or discovered by the interpretive process, privacy, choice, dignity, etc. Repeatedly, the decisions of the court have emphasized on the non-discriminatory and positive content of certain fundamental rights. In fact, the court has underlined the obligations of the state to create conditions conducive to the exercise of the right to equality and to realize fraternity. Refer to the decisions in Thomas and Indira Sani, which expanded the understanding of substantive equality, though without making enabling provisions enforceable by the court. This court also in some decisions accepted the argument that given the nature of fundamental rights and their evolving content, in many circumstances, it might be necessary for the state to intervene and protect the fundamental right concerned, thus creating an atmosphere conducive for the enjoyment of such right. Lata Singh dealt with honor killings of couples. In Arumugam Sirvai, the issue was virulent caste slurs and violence, which were crimes. The court required administrative and police officials to take strong measures to prevent them. In Shakti Wahini, Shakti Wahini dealt with threats by Khap Panchayats, and the court held that the state is duty bound to protect fundamental rights, and an inherent aspect of Article 21 of the Constitution would be the freedom of choice. The court issued directions. The judgment of the learned Chief Justice propounded a theory of a unified thread of rights, entitlements flowing from it, and how lack of recognition results in deprivation of the specified rights under Articles 19 and 25, in addition to Article 21. To the extent that assertion of sexual or gender identity in exercise of free speech, association, to express manifestations in whatever form are concerned, one cannot join issue. Equally, if by some state process, measures or conduct has been barred from expressing one's choice publicly, the reasonableness of that prohibition or order can be tested on grounds enumerated in Article 19(2) and other grounds. However, when the law is silent and leaves the parties to express choice, Article 19(1)(a) does not oblige the state to enact a law or frame a regulation that enables facilitation of that expression. All judgments of this court were based on effects of laws or policies based on statutory provisions. Equally, in the absence of a legal framework enabling citizens to form a particular kind of association, as for instance, recognition of a limited liability partnership, which was not recognized and given legal status till recently, the court could not have validly created the regime by enabling recognition or regulating such associations. Similarly, the absence of any enacted law which uh, enables facilitation of transport, it is hard to visualize that a citizen can approach the court and seek the construction of a road to enforce the right to travel, or seek the court's intervention to create a network of roads. Likewise, the absence of basic housing. Again, the court, if approached for enforcement of 19(1)(a), would not call upon the state to create one by either framing a general legislative policy or through law. Furthermore, this court has also recognized that there can be even reasonable restrictions in the acquisition and enjoyment of certain types of properties in many states. Given the nature of rights under Articles 19 and 21, the enjoyment of which are limited to the extent reasonable laws within the bounds of specified provisions, the enact in the legitimate jurisdiction of this court, it would be difficult to translate positive obligations as articulated by the learned Chief Justice's opinion. There is no difficulty about the right of two consenting persons to decide to live together, to cohabit, and create their unique idea of home, unconstrained by what others say. This is the sequitur to Puttaswamy and Navtej. Conduct hitherto criminalized is now permissible. The liberative effect of section 377 being read down is that two individuals, regardless of their sexual orientation, are enabled to live together with dignity and also protected from any kind of violence for living and existing together. Therefore, the right to be left alone, the right to exercise choice, right to dignity and live one's life with the person of one's choice is an intrinsic and essential feature of Article 21. Even if we want to, for argument's sake, recognize an entitlement under the Constitution to enter into an abiding cohabitational relationship or union, in our opinion, it cannot follow to a claim for an institution. There are almost intractable difficulties in creating, through judicial orders or diktat, a civil right to marry or a civil union, no less of the kind that is sought by the petitioners. Ordering a social institution or rearranging existing social structures by creating an entirely new kind of parallel framework for queer couples would require conception of an entirely different code, a new universe of rights and obligations. This will entail fashioning a regime of state registration of marriage between queer couples, the conditions for a valid and matrimonial relationship amongst them, spelling out eligibility conditions such as minimum age, relationships which fall within prohibited degrees, grounds for divorce, right to maintenance, alimony, etc. The learned chief, as a result, with due respect, we are unable to agree with the conclusions of the learned Chief Justice with respect to tracing the right to enter into or form unions from the right of freedom of speech and expression, the right to form associations, along with right any other corresponding positive obligation. It is reiterated that all queer couples have the right to relationship and choice of partner, right of cohabitation as an integral part of choice linked to their privacy and dignity. Any further discussion on the rights which consenting partners may exercise is unnecessary. No one has contested that two queer couples have the rights enumerated under Articles 19(1)(a), C, and D, or even the right to conscience under Article 25. The elaboration of these rights to say that the exercise of choice to such relationships renders these meaningful and that the state is obligated to recognize a bouquet of entitlements which flow from such abiding relationship of this kind is not called for. We therefore respectfully disagree with that part of the learned Chief Justice's reasoning, which forms the basis for some of the final conclusions and directions recorded in his judgment. Agree with the conclusions of the learned Chief Justice with respect to the inapplicability of the SMA, and we also add certain observations. A gender neutral interpretation of SMA and its provisions, much like many seemingly progressive aspirations, may not really be equitable at times and can result in women being exposed to unintended vulnerability, especially when genuine attempts are made to achieve a balance in a social order that traditionally was tipped in favor of cis heterosexual men. The purpose of the terms like wife, husband, man, and women in marriage is to protect a socially marginalized demographic of individuals. For instance, women facing violence by their partner have a right to recourse under the Domestic Violence Act, which assures and is meant to assure that the victims are safeguarded and provided relief. In fact, provisions of SMA for alimony maintenance confer rights to women. Likewise, certain grounds of divorce, conviction of husband for bigamy, rape, etc., entitle the wife additional grounds. Other provisions enact separate degrees of prohibited relationships. Section 4C uses the term husband and wife. There are other provisions which deal with, which specifically used gendered terms. The general pattern of these provisions, including the specific provisions enabling or entitling women certain benefits and the effect of sections 19 to 21A, is that even if, for argument's sake, it were accepted that section 4 could be read in gender neutral terms, the interplay of other provisions which could apply to such queer couples in such cases would lead to anomalous results, rendering the SMA unworkable. It is important. Now, there's a section that deals with the discriminatory impact on queer couples. It is important to recognize that while the state ipso facto may have no role in the choice of two free-willed individuals to marry, it's characterizing marriage for various collateral and intersectional purposes, such as permanent and binding legal relationships, recognized as such between heterosexual couples only, and no other impacts queer couples adversely. The intention of the state in framing the regulations or laws is to confer benefits to families or individuals who are married. This has the result of adversely impacting the queer couples. By recognizing heterosexual couples union and cohabitation as marriages in various laws and regulations, as in employment or nominations in pension, provident fund, gratuity, life and personal accident insurance policies, for credit, particularly joint loans to both spouses, based on their total earning capacity, for purposes of receiving compensation in the event of fatal accidents, to name a few, and not providing for non-heterosexual couples results in their exclusion. The individual earned benefits by each partner or both collectively, which would be available to family members, such as employee state insurance benefits in the event of injury of an earning partner, provident fund, compensation, medical benefits, etc., are examples of what the injured or deceased partner, by dint of her or his work, became entitled to, or the members of her family became entitled to. The denial of these and inability of the earning partner in a queer relationship, therefore, has an adverse discriminatory impact. The state may not intend the discrimination or exclusion in the conferment of such benefits or social welfare measure. Yet the framework of these policies expressed in favor of those matrimonial relationships results in denial of entitlements despite the professional abilities and contributions which the individual might make to society. The objective of many of these laws or schemes is to confer or provide entitlements based on individual earning and contribution. For example, Provident Fund is payable due to the employee's personal contribution and status as employee. Similarly, objective entitlement of benefits of employees' state insurance, etc., flow from individual status, work, and effort. Major part of these benefits, or all of them, flow in the event of certain eventualities such as fatal accident or death. The design of these statutes and schemes is to enable both the concerned subscriber or the employee to receive them, or in an unforeseen event such as death, for his dependents to receive them. The restrictive way in which dependent or nominee excludes their enjoyment to the intended beneficiary. Addressing all these aspects and concerns means considering a range of policy choices and involving multiplicity of legislative architecture governing the regulations guided by diverse interests and concerns, many of them possibly coalescing. On 3rd of May 2023, during the course of the hearing, the learned Solicitor General, upon instructions, had expressed the Union's position that a high-powered committee headed by the Union Cabinet Secretary comprehensive examination to consider such impacts and make suitable recommendations in that regard. So we proceed to agree with the learned Chief Justice's conclusions with regard to the right of transgender persons in heterosexual relations to marry under existing laws. On the issue of adoption, we express our disagreement and voice our concerns in the following manner. We have voiced our concerns and laid it out in some detail, which I do not wish to read. This is not to say that unmarried couples, whether queer or heterosexuals, are not capable or suitable to be adoptive parents. However, once the law permits, as it has done, adoption by both single individuals, the likelihood of their joining and cohabiting cannot be ruled out. In such event, de facto family unit can and does come about. The underlying assumption in the law as exists is that such unmarried heterosexual or queer couples should not adopt. It needs to be closely examined. Similarly, the needs of such couples to have and raise a family in every sense of the term has to be accommodated within the framework of the law. The existing state of affairs which permits single individuals to adopt and later live as a couple in exercise of their choice, in effect deprives the children of such relationships various legal and social benefits which are otherwise available, given the objective of to a married couple. In other words, given the objective of Section 57, the state as parens patriae needs to explore every possibility and not rule out any policy or legislative choice to ensure the maximum welfare and benefits reach the largest number of children in need of safe and secure homes with a promise for their fullest development. Response to the learned Chief Justice's comments on our draft, which I propose to read, part of which I propose to read. This court's observations with respect to the learned Chief Justice's reasoning centered around the enunciation of the bouquet of rights emanating from his provisions and locating an obligation has to be seen in the backdrop of the unanimous view of this court that the fundamental right to marry is not found within the Constitution. Therefore, it is our considered opinion that to create an overarching obligation upon the state to facilitate through policies the fuller enjoyment of rights under Articles 19 and 25 is not rooted in any past decision or jurisprudence. That queer couples have the right to exercise their choice, cohabit and live without disturbance is incontestable. In the same way that they are owed protection against any threat is the natural corollary of their right under Article 21. Consider in this context also the nature of relief sought and the positive obligation fashioned. Whilst there are innumerable judgments on the positive contents of the rights under Article 21, there are countless judgments that insist upon the separation of powers when it comes to matters of policy and the courts not being the appropriate forum for adjudication of the same. The polycentric nature of this issue is compelling. Next, as to the reasoning that our conclusion on the challenge of SM and subsequently finding on the disparate discriminatory impact faced by the queer community, a small comment is called for. The section discussing the provisions of the SMA and the challenge to its validity was based upon whether it violated the Constitution on the ground of impermissible classification under Article 14, for which the object of the Act to facilitate marriage between interfaith couples, wherein at the time marriage or even a couple only denoted heterosexual couples in the light of same-sex relationships being criminalized, and its provisions are relevant factors. Classification involves differentiation. Further, this court has discussed how underclassification per se does not warrant invalidation. In contrast, in the later segment on discriminatory impact, the issue that this court was considering was not reasonable classification, but impact upon queer couples through neutral laws or regulations that they encounter in their everyday lives, the purpose of which or even their substantive provisions have nothing to do with marriage. It is rather to confer other benefits, many of which are earned or accrued on account of individual skill. Yet the framing of these benefits or their intended beneficiaries were articulated in terms of entitlement to families or spouses, tends to exclude from its ambit queer couples. When such queer couples are entitled to benefits wherever they fulfill other eligibility criteria, it is the disparate impact of these neutral laws in the disbursement of entitlements or benefits which is seen through the effect or impact lens. Therefore, the discussion on constitutionality of SME is markedly different from the section on discriminatory impact in certain points for queer couples, as they have no avenue for marriage like heterosexual couples. In the latter, the impact of various laws were pointed as starting point for the state to take remedial action. Be sorely mistaken if we presume what the queer community in all its diversity seeks and lays it out as a formaic framework. Many may welcome civil unions as a pragmatic first step, while some may find it yet to be another inequitable solution to the feeling of exclusion that persists in society against this community, and one which simply repackages the stigmatization felt. Many may desire marriage as understood in the traditional sense to escape their societal realities, a form of financial and social emancipation from opposing natal families, or diametrically opposite, to assimilate and gain more social acceptance. Yet others may, as a result of their experience, reject altogether the institution of marriage and all the social obligations and associations that come with it, but still want protection of their rights. Certainly, what the former group may want does not hamper or hinder the latter in any manner, for it is a choice that they seek. That the state should facilitate this choice for those who wish to exercise it is an outcome that the community may agree upon. Yet the modalities of how it should play out, what it will entail, are facets that the state, here the legislature and the executive, needs to exercise its powers in furtherance of. Now, whether this will happen through a proactive action of the state or as a result of sustained public mobilization is a reality that will play out in India's democratic stage, and something only time can tell. The state may choose from a number of policy outcomes. They may make all marriage and family related laws gender neutral, or may create a separate SMA-like statute in gender neutral terms to give the queer community an avenue for marriage. They may pass an act creating civil unions or a domestic partnership, among the many other alternatives. Another consequence may be that rather than the union, the state legislature takes actions or enacts law. What is, however, certain is that in question of such polycentric nature, whether social or political, the court must exercise restraint and defer to the wisdom of the other branches of the state, which can undertake wide-scale public consultation, consensus building, and reflect the will of the people and be in their best interest. If as a result of this, a law is enacted that undermines or violates the constitutionally protected rights of an individual, no matter how minuscule, their right to seek redressal from this court is guaranteed. That the petitioners seek what many of us may deem to be normal or accepted next step in the life upon attaining a certain age, and perhaps take for granted is not lost on us. Their desire for social acceptability in the manner that has been historically known, through the social recognition that marriage affords, and the lack of which causes them the feeling of exclusion and hurt, is one that, as individuals, especially donning the robes of justice, we can certainly have deep empathy with. However, we are deeply conscious that no matter how much we empathize with the outcome sought, the means to arriving at such a destination must be also legally sound and keep intact the grand architecture of our constitutional scheme. If we throw caution to the wind, we stand at the risk of paving the way, wherein each brick may feel justified to untold consequences that we could not have contemplated. While molding relief as a code, we must be cognizant that despite being empowered to see the capabilities of the law in its grand and majestic formulation, we must not be led aground because we are blinded by its glow. Now I pass on to read the conclusions and the final directions that we have summarized. The court hereby summarizes its conclusions and directions as follows. There is no unqualified right to marriage except that recognized by statute, including the space left by custom. 2. An entitlement to legal recognition of the right to union, akin to marriage or civil union, or conferring legal status upon the parties to the relationship can be only through enacted law. A sequitur of this is that the court cannot enjoin or direct the creation of such a regulatory framework, resulting in legal status. The finding in 1 and 2 should not be read as to preclude queer persons from celebrating their commitment to each other or relationship in whichever way they wish within the social realm. 4. Previous judgments of this court have established that queer couples have a right to union or relationship, be it mental, emotional, or sexual, flowing from the right to privacy, right to choice, and autonomy. This does not, however, extend the right to claim a legal entitlement to any legal status for the said union or relationship. The challenge to SMA on the ground of underclassification is not made out. Equality and non-discrimination are basic foundational rights. The indirect discriminatory impacts on relations in relation to earned or compensatory benefits or social welfare entitlements to which marital status is a relevant eligibility criteria for queer couples who exercise choice to form relationships have to be suitably addressed and removed by the state. These measures need to be taken with expedition because inaction will result in injustice and unfairness with regard to enjoyment of these benefits available to all citizens who are entitled and covered by such laws. As held earlier, this court cannot, within the judicial framework, engage in this complex task. The state has to study the impact of these policies and entitlements. Consistent with the statement before this court during the course of the proceeding, the union shall set up a high-powered committee chaired by the Cabinet Secretary to undertake a comprehensive examination of all relevant factors, especially including those outlined above. In the conduct of such exercise, the concerned representatives of all stakeholders and the views of all states and union territories shall be taken into account. The discussion on discriminatory impacts is in the context of effects of the existing regimes on the queer couples. When a heterosexual couple's right to live together is not contested, the logic of the discriminatory impact faced by queer couples cohabiting together would definitionally, however, not apply to them. Transgender persons in heterosexual relationships have the freedom to and entitlement to marry. Regulation 5.3 of CARA regulations cannot be held void. At the same time, the court is of the opinion that CARA and the central government should appropriately consider the realities of de facto families where single individuals are permitted to adopt and thereafter start living in a non-matrimonial relationship. In an unforeseen eventuality, the adopted child in question could face exclusion from the benefits otherwise available to adopted children of married couples. This aspect needs further consideration, for which the court is not the appropriate forum. Furthermore, the state shall ensure, consistent with the previous judgments of this court, that the choice exercised by the queer and LGBTQ couples to cohabit is not interfered with, and they do not face any threat of violence or coercion. All necessary steps and measures in this regard shall be taken. The respondent shall take suitable steps also to ensure that queer couples and transgender couples are not subjected to any involuntary medical or surgical treatment. The above directions are in relation to transgender persons are to be read as part of and not in any manner whittling down the directions in NALSA, supra, so far as they apply to transgender persons. The questions are disposed of in the above terms.
View of Brother Ravi Bhat as stated in the judgment.
I am conscious of the ordeals that arise from multiplicity of judicial opinions in cases involving constitutional questions. Here I consider it worthwhile to pen the present opinion given the significant nature of the questions involved. Polyvocality in the exercise of adjudicatory function may not necessarily be viewed with discomfort if complemented with judicial discipline. It is truly reflective of diversity of judicial thought. At the very outset, I have given my conclusions while agreeing with the opinion of Justice Bhat. I will read the conclusions. The question of marriage equality of same-sex LGBTQ couples did not arise for consideration in any of the previous decisions of this court, including the decision in Navtej Nalsa. Consequently, there cannot be a binding precedent on this court. The reasons for arriving this conclusion are articulated in detail with Justice Bhat. The rights of LGBTQ persons that have been hitherto recognized by this court are the rights to gender identity, sexual orientation, the right to choose a partner, cohabit and enjoy physical and mental intimacy. In the exercise of these rights, they have full freedom from physical threat and from coercive action, and the state is bound to afford them full protection of law in cases these rights are in peril. Third, there is no unqualified right to marriage guaranteed by the Constitution that qualifies it as fundamental right. I have given my detailed opinion. In one paragraph, I would read that. In my considered opinion, the institutional space of marriage is conditioned and occupied synchronously by legislative interventions, customary practices, and religious beliefs. The extant legislative accommodation of customary and religious practices is not gratuitous and to some extent conditioned by the right to religion and right to culture, constitutionally sanctified in Article 25 and 29 of the Constitution. This synchronously occupied institutional space of marriage is a product of our social and constitutional realities, and therefore, in my opinion, compared to judicial perspectives, offer little assistance. Given this nature of marriage as an institution, the right to choose a spouse and the right to a consenting couple to be recognized within the institution of marriage cannot but be said to be restrictive. Coming back to the conclusion, right to marriage is a statutory right, and to the extent it is demonstrable, a right flowing from a legally enforceable customary practice. In the exercise of such rights, statutory or customary, the state is bound to extend the protection of law to individuals so that they can exercise their choices
without fear and coercion. This, in my opinion, is the real import in the decision in Safin Jahan and Shakti Vahani. The constitutional challenge to Special Marriage Act 1954 and Foreign Marriage Act must fail for the reason indicated in the opinion of Justice Bhat. Similarly, Justice Bhat also rightly finds the semantic impossibilities of gender-neutral constructions of the Special Marriage Act and Foreign Marriage Act. On both E and F of his opinion, Justice Bhat has exhaustively as to the reasons that they need not now be supplemented. I find no right to civil union or an abiding cohabitational relationship conferring a legally enforceable status cannot be situated within Part 3 of the Constitution. On this count, I too agree with Justice Bhat, but I have supplemented it, in my opinion, having considered that there exists no unqualified right to marry. In the ordinary course, no occasion would have arisen for any further deliberation. However, as the learned Chief Justice, in his opinion, has arrived at a conclusion that there exists a constitutional right to a union or an abiding cohabitational relationship, it is necessary for me to express my opinion on this newfound construction. The learned Chief Justice locates components of the right to union or an abiding cohabitational relationship under Articles 19(1)(a), C, E, 21 and 25 of the Constitution. In my opinion, it would not be constitutionally permissible to identify a right to a union or an abiding cohabitational relationship mirroring the institution of marriage. The learned Chief Justice identifies tangibles and intangible benefits, that is, bouquet of entitlements that arise from state recognition and regulation of marriages. The Chief Justice further opines that the right to marriage is not fundamental. However, it is in these tangible and intangible benefits, the denial of which, according to the learned Chief Justice, must inform the reading of a constitutional right to an abiding cohabitational union. In other words, the benefits of marriage, however fundamental to a fulfilling life, do not make marriage itself a fundamental right, but they render the right to an abiding cohabitational union fundamental. I find it difficult to reconcile these two principles. I finally conclude, I will read the last two. I also agree with the reasoning and the conclusions of Justice Bhat with respect to constitutionality of regulations 5(3) of CARA regulations. I have concluded with what I strongly feel. I am not oblivious to the concerns of LGBTQ partners with respect to denial of access to certain benefits and privileges that are otherwise available only to married couple. The general statutory scheme for the following benefits, gratuitous or earned, property or compensation, leave or compassionate appointment, proceed on a certain definitional understanding of partner, dependent, caregiver, and family. In that definitional understanding, it is no doubt true that certain classes of individuals, same-sex partners, live-in relationship, and non-intimate caregivers, including siblings, are left out. The impact of some of these definitions is iniquitous and sometimes discriminatory. The policy considerations and legislative frameworks underlining these definitional contexts are too diverse and to be captured and evaluated within a singular judicial proceedings. I am of the firm belief that a review of the impact of the legislative framework on the flow of such benefits requires a deliberative and consultative exercise, which exercise the legislature and executive are constitutionally suited and tasked to undertake.
Thank you very much.
Thank you.